This video is about Torts Law 1. A tort, I jokingly say that TORTS is an acronym for the only reason they sue, but really a tort is a wrongful act or an infringement of a right other than under contract leading to civil legal liability. But in this video, we're going to go over the following torts: negligence, as well as causation. We're also going to go over affirmative defenses, damages, apportionment of damages, strict liability, as well as intentional torts, and finally, property torts. The elements of the tort of negligence are injury, duty, breach of duty, causation, which includes actual causation and proximate causation. So, injury, the rule is an injury is a cognizable injury, which or legally identifiable injury, which includes physical harm, economic harm, and emotional harm. So, let's go into duty next. So the rule of duty is the defendant must act with the same care and a reasonable person would in like circumstances. Every person owes a duty to another person to use reasonable care to avoid causing injury to them or their property. This is a matter of law. So, under the second element of negligence, the first one being injury, the second one being duty, general duty of ordinary care is what a reasonable, prudent person should do under similar circumstances. Duty hinges on the reasonable foreseeability of risk. So there's two different approaches when it comes to duty. There's Andrews' approach, and this was based off of a judge in the past named Andrews. And his approach was we owe a duty to everyone. A case in which he gave his opinion is the Palsgraf case. Also, Justo Cardozo's approach is we only owe a duty to those in the zone of danger. Again, Palsgraf is a case in which he gave his majority opinion. There are special relationships when it comes to duty, such as parent child, spouse, innkeeper guest, common carrier for public and private transit. Also, there's a special relationship when it comes to duty if there is a voluntary undertaking to warn, protect, or rescue. If you choose to volunteer or protect someone or rescue someone, you can generate a duty to do so. When a defendant has a hand in placing a plaintiff at risk of harm, the defendant may incur a duty to take reasonable steps to warn, protect, or rescue. A possessor of land who holds it open to the public has a special relationship regarding duty, and one who is required by law to take or who voluntarily takes that custody of another under circumstances such as to deprive the other of his normal opportunities for protection. In continuation of our discussion about the duty element of negligence, there's premises liability. The rule regarding premises liability is a property owner has a legal responsibility to prevent injuries caused by unsafe conditions. An invitee to someone's property is a person who's basically a customer on business owned property. So the property owner owes a duty to use reasonable and ordinary care to keep the premises safe for the invitee and to protect the invitee from injury caused by the unreasonable risk. The duty to inspect for danger and address danger is also on the owner of land in which they invite an invitee. So, with regards to the duty owed to a licensee in reference to premises liability, is the owner of the property owes a duty to warn the person of any foreseeable harm that the owner is aware of or should be aware of. The owner has a duty to inspect. A example of a licensee is a party guest. And then there is a trespasser with regards to premises liability under the tort of negligence. So, with regards to a trespasser, the owner of property owes a duty to not wantonly, willfully, intentionally, or knowingly harm them. With regards to landowners, in reference to invitees, the injury has to do with a condition of the premises. With regards to innkeepers and their invitees, the injury may not be their fault. However, there is a duty to stay with the plaintiff until help comes and administer first aid if necessary. So, even though the injury may not be the fault of the property owner or their agents have a duty to stay with the plaintiff until help comes and administer first aid if necessary. Okay, so there, under negligence, under the tort of negligence, there is a duty owed to children. And this is broken up in a few different things, such as the Massachusetts rule, the tender years doctrine, exception to the Massachusetts rule, and the tender years doctrine, and another duty owed to protect negligent acts toward children. So, under the Massachusetts rule, this was found in Applehans v. McFall. Children of like experience and intelligence and age in the same situation. So the Massachusetts rule is basically saying that a child's degree of liability will be determined by looking at the average conduct of children of the like experience, intelligence, and age in the same situation. So the tender years doctrine, children under the age of 7 are not subject to negligence. Children who are 7 are subject to negligence. So an exception to the Massachusetts rule and the tender years doctrine is adult activities doctrine. If a child engages in an adult activity, such as driving a motorized vehicle, smoking, or drinking while conducting a negligent act, no matter the age, then they can be held liable for negligence. Another duty owed to protect negligent acts toward children is attractive nuisance. A potentially dangerous condition exists on the property. That's pretty much the crux of an attractive nuisance. So what makes a nuisance attractive? What makes an attractive nuisance? It's when there is a potential dangerous condition that exists on the property. The landowner maintained or created the potential danger. Basically, the danger has to be man-made and not natural. The landowner should have known the condition would attract children. The landowner should have known the condition would harm children. And there's essentially 6 different elements when it comes to the attractive nuisance doctrine in relation to duties owed to protect the negligent acts toward children. Number 1, injury to trespassing child was reasonably foreseeable. Number 2, danger on land presented unreasonable risk of harm to trespassing children. Number 3, danger on land was artificial, man-made, rather than natural. Number 4, because of child's youth, he or she could not appreciate risks involved or did not discover or understand the threat. Number 5, threatening condition was located at a place across which children were likely to trespass. And number 6, occupier failed to exercise reasonable care to protect trespassing children from danger that caused harm. The discussion about the tort of negligence continues in reference to breach of duty. So with regards to breach of duty, it is determined by if the defendant violated the reasonable person standard. One person owes another a duty of care but fails to fulfill that duty. This is a matter of fact or a matter of evidence. So this is, describes the breach of duty. With regards to custom, well, there's the T.J. Hooper rule as well as the anti-T.J. Hooper rule. And so the T.J. Hooper rule does not apply when there's a claim for professional negligence. If, the defendant acted like others in that profession who are qualified as a matter of law, then there is no breach. If you are arguing that the defendant acted out of custom, that defense is persuasive and dispositive. So basically, the TJ Hooper rule is industry custom. It is persuasive, but not dispositive. Even if a defendant has acted with the same care that, under the circumstances, is customary for persons or entities such as the defendant to take, that fact alone does not establish that the defendant used the level of care required by the reasonable person standard. This is what everyone else is doing or not doing. It's not a very good defense. This is relative but not dispositive. Now let's go into the anti-TJ Hooper rule. It was illustrated in the case of Condra v. Atlanta Orthopedic. So in the anti-TJ Hooper rule, industry custom is dispositive and sets the standard of care. The plaintiff must prove that the defendant deviated from the standard of care used by members of her profession. Relevant evidence for the jury to consider includes evidence regarding an expert witness's personal practices are admissible as substantive evidence regarding the applicable standard of care in medical malpractice cases. And then let's go into the learned hand formula under breach of duty for negligence torts. The learned hand formula is dispositive. If the burden is less than the probability multiplied by the loss, then there is negligence. However, if the burden is greater than the probability multiplied by the loss, then there is no negligence. So probability is multiplied by the loss as a way to assess reasonable person standard via formula. So the risk utility formula is the same thing. The learned hand formula is the risk utility formula. The plaintiff's injury must be within the scope of risk and not too remote from the defendant's actions. And when I say if the burden is less than or greater than, the burden is the cost and effort, things like that, it would take to prevent the injury. That's what I'm talking about. So let's go on to negligence per se, which is under the tort of negligence, with regards to the element of breach of duty. So negligence per se is a matter of law. The defendant violated a safety statute. The violation of the statute caused plaintiff's injuries. The defendant's conduct caused the harm the statute was designed to prevent, and the plaintiff was part of the statute's protected class. Now let's go into res ipsa loquitur, if I'm pronouncing that correctly. This is also under the element of breach of duty under the tort of negligence. The thing that speaks for itself is what res ipsa loquitur means. It's used when there is no evidence that defendant was at fault. The occurrence of the injury implies negligence. The incident was of a type that does not generally happen without negligence. It was caused by an instrumentality solely in defendant's control, and the defendant did not contribute to the cause. This is a defense/argument of the plaintiff against the defendant. Under the tort of negligence, there is causation, and causation is split between actual as well as proximate causation. So under causation, the plaintiff must prove that the defendant caused the alleged tort. Actual causation, also known as cause and fact, can be discovered by the but-for test, which is when someone says, but for this happening, then the injury would not have happened. There are multiple necessary causes when all careless actors function as a necessary condition of an injury. Each is the actual cause of the injury. The but-for test can be used for each individual actor when it comes to seeing if the actors were the multiple necessary causes. So, multiple sufficient causes is when multiple actors or multiple acts occur. Each act under the but for causation test would have been an actual cause of the physical harm even in the absence of the other acts. There is an exception. If one of these independently sufficient causes brings about the injury before the other, the second is typically deemed a preempted cause for which no liability attaches. Preempted cause definition in context. It is preventing them from passing blame on the second actor. So, proximate cause. A defendant may be deemed liable for negligence where the nature of the risk and the type of injury were reasonably foreseeable, even if the precise manner and extent of the injury were not. Remember, it must be a natural consequence of the careless act or omission of the defendant, and the resulting injury cannot be too remote from defendant's actions. With regards to foreseeability, it means whether it was foreseeable the injury would have occurred. So Andrew's approach is nearly everything is foreseeable. Foreseeability of the injury is not the only harm that matters. It kind of, portrays a rough sense or a wrought sense of justice. No relational aspect is needed under Andrew's approach to foreseeability or foreseeable harm. Remoteness in time plus space also relate, and the act must be a substantial factor to plaintiff's injuries. Foreseeability is connected to duty and causation. Duty to a plaintiff depends on if plaintiff's injury was foreseeable in relation to defendant's conduct. So let's go into scope of risk. A harm is within the scope of risk if a reasonable person in similar circumstances could have foreseen the harm of the same general type, and plaintiff must fall within the class of persons risked by the defendant's negligence. So under the tort of negligence, we continue to describe a superseding cause. So under the element of causation, the superseding cause is an intervening act that cuts off liability to the defendant even though the defendant played a role in the victim's injury. Actions must happen in sequence and they have to be independent of each other. And with regards to superseding causes, a crime committed by another cuts off liability from defendant. Now let's go into the affirmative defenses with regards to the tort of negligence. So one affirmative defense is the contributory negligence, also the last clear chance rule, comparative responsibility or comparative fault, and let's see. Alrighty. So with regards to the contributory negligence, in the District of Columbia, as well as the state of Maryland, Virginia, North Carolina, or Alabama, found the plaintiff to have contributed to their injuries, the plaintiff would be barred from recovery. If you can prove that the defendant had the last clear chance to prevent the injury and they did not take it, then the plaintiff can use the last clear chance defense. When the plaintiff is at fault to any percentage greater than 0%, the careless defendant is not a cause of the injury. The plaintiff's conduct is the only legally relevant cause, and this was found in Smith v. Smith in 1824. That is contributory negligence. So contributory negligence, it is a complete defense. It is an exception, or one of the exceptions to the contributory negligence defense is the last clear chance rule. The limits to the contributory negligence defense is intentional torts and last clear chance. So contributory negligence does not extend to claims alleging recklessness or intentional wrongdoing by the defendant. Carelessness by the plaintiff was irrelevant for battery and false imprisonment. Contributory negligence under the tort of negligence was abandoned for comparative fault. We do not want, the reason why it was abandoned for comparative fault is because we do not want to reward plaintiffs for falling underneath the standard of care. When you see contributory negligence, argue comparative responsibility. So let's dig into that last clear chance rule. It's best defined by an example at first. So there's a speeding train conductor, and then there's a farmer who gets stuck, on the tracks. The speeding train conductor, for no good reason, did not apply the brakes, which could have avoided the accident, and strikes the plaintiff farmer. If the defendant, the train conductor, has the last opportunity to prevent an accident and does not take it, then the defendant, the train conductor, will not enjoy the benefit of using the contributory negligence defense. So the definition of the last clear chance rule is if a defendant has the last opportunity to prevent an accident resulting from careless acts for both the defendant and the plaintiff, the defendant will not be protected by the contributory negligence defense. This is plaintiff's response to defendant's contributory negligence argument. If the last clear chance is accepted by the court, then comparative fault is used by the defendant. So let's get into comparative fault, also known as comparative responsibility. And so this is true for all other states, and this reduces the plaintiff's damages. So if any state beside the District of Columbia, Maryland, Virginia, North Carolina, and Alabama find the plaintiff to have contributed to their own injuries, the plaintiff receives reduced damages, which lead to comparative fault. For example, if the jury found that the plaintiff was 30% negligent, then they would receive 70% of the damages. And if they found that the plaintiff was 40% at fault, then the plaintiff would receive 60% of the damages. This is pure comparative negligence. On the other hand, if the jury found that the plaintiff was 50% or more at fault for their injuries, then the plaintiff will receive no damages. This is what we call modified comparative negligence. This is a per se bar to recovery. However, the jury is the fact finder to decide whether the plaintiff contributed to their own injuries. So a comparative fault describes the degree of carelessness of plaintiff and defendant. Apportionment of liability describes how the liability is to be shared between co-defendants and plaintiffs versus defendants. So apportionment of liability can be shared between intentional tortfeasors and negligent tortfeasors. Usually, comparative responsibility, also known as comparative fault, usually is not a complete defense. It compares the fault of each party to determine how much each contributed to the injury. Plaintiff's damages are reduced. And this is because we do not want to reward plaintiffs for falling underneath the standard of care. There are two different kinds of comparative responsibility or comparative fault: modified and pure comparative fault. Modified comparative fault or modified comparative responsibility is if the plaintiff is 50% or more at fault, her right to recovery is barred. Under pure comparative fault, the plaintiff can recover 1% of damages. This is something that the plaintiff will argue. Even if the plaintiff is majority at fault for their own injury, the plaintiff may still recover damages under pure comparative fault. Once a percentage is apportioned to each party, the plaintiff may recover the difference in damages. So let's just go into some definitions here. The definition of affirmative defense is a new matter constituting a defense. A new matter which, assuming the complaint to be true, constitutes a defense to it. That is an affirmative defense. So let's go into the assumption of risk under negligence law, or under a negligence tort in reference to comparative responsibility, comparative fault. So under the assumption of risk, there is implied and expressed. For assumption of risk, implied is if a party proceeds toward the risk with knowledge and appreciation or understanding that they are at risk, then the party is barred from recovering from a tortfeasor for any harm. So if there's harm within the risk, it includes any harm inherent to the activity. So let's go into expressed assumption of the risk. Express assumption of the risk, can be seen in a signed waiver, a vocal expression. This typically comes in the form of an adhesion contract. An example is an employment agreement, which is not up for negotiation. These are a complete defense for the defendant and a complete bar of recovery for the plaintiff. Assumption of risk, implied and expressed. Exculpatory agreements, exculpatory agreements will generally be upheld where they are freely and fairly made between parties who are in an equal bargaining position and there is no social interest with which they interfere. Such agreements, hence the exculpatory agreements, relieve the service provider from any liability resulting from loss or damage sustained by the participant. All right, so let's get into damages. So under the tort of negligence, damages is a trial that is separate from the initial liability trial using the same jury. So there's compensatory damages, punitive damages, and then we'll get into joint and several liability, injunctive relief, and the eggshell skull rule. And then we'll dive a little deeper into joint and several liability, as well as contribution and several liability. So compensatory damages include economic damages, money, non-economic, and pain and suffering. So for permanent personal injury, it's not excessive where it reasonably relates to the nature and extent of the injuries with regards to the victim's age, present and future economic losses and costs, and awards made in comparable cases. So this was found in Kenton v. Hyatt Hotels Corporation. So with regard to punitive damages, a plaintiff must prove malice. They must prove wantonness, extreme or gross recklessness to get punitive damages. For a plaintiff to get punitive damages, they must ask for punitive damages. The jury has wide discretion whether to award them. Punitive damages punitive damages serve to punish the defendant. Some jurisdictions require plaintiffs to suffer other than nominal damages. They are rarely awarded in negligence claims. They are found more often in battery claims. Standard negligence does not involve the requisite willfulness, malice, and recklessness. The award is not impermissibly excessive merely because the ratio between compensatory and punitive damages exceeds single digits. This was found in Matthias v. Accor Economy Lodging Incorporated. With regards to punitive damages, it requires evidence that the defendant proceeded intentionally knowing the act was naturally and likely to cause injury. This was found in National Byproducts Incorporated versus Searcy House Moving Company. and it is not required to show the defendant deliberately intended to injure the plaintiff in order to be awarded punitive damages. So let's go into the joint and several liability under the tort of negligence. So for joint and several liability, what's needed is multiple tortfeasors are necessary, concept, action, or conspiracy or indivisible harm, and contribution is necessary. For injunctive relief, what's needed is a court order for a defendant to do or stop doing something. It rarely is found in negligence cases. Also, injunctive relief more often is present in trespass and nuisance cases. So the eggshell skull rule in the tort of negligence, take the plaintiff as he finds him. That's basically what the eggshell skull rule is. So damages will not be limited if the plaintiff had pre-existing conditions. The eggshell skull rule prohibits the defendant from arguing that the jury is barred from awarding compensation for the unforeseeable portion of plaintiff's damages. The defendant may be liable for damages in negligence where the victim's type of injury is foreseeable, even if the extent of such injury was not. Foreseeability of the extent of such injury matters not. Well, let me say that again. Foreseeability of the extent of such injury matters not. And this was found in Smith v. Leach Brain and Company, Ltd. So, with regards to the eggshell skull rule, it was created and enforced for deference or deterrence. It's the initial injury must be foreseeable. So let me just reiterate. The eggshell skull rule was created and enforced for deterrence of torts. And, the eggshell skull rule, it covers the initial injury, as the initial injury must be foreseeable. Then there is the collateral source rule. The collateral source rule says you don't want to punish someone for having insurance or doing the right thing. The evidentiary rule prohibits the defendant from bringing evidence to a jury about other sources of payment for the incident. So let's go into joint and several liability. This is where you would need multiple tortfeasors. The concept, action, or conspiracy or indivisible harm must be present, and there must be a contribution to the harm. So the issue of joint liability and contribution between the two or more tortfeasors, who has to pay what amount to plaintiff? It is a damages rule. So it's used when it's difficult or impossible to distinguish which injuries were caused by which tortfeasor. One defendant is on the hook for 100%. If damages caused by each cannot be separated, then either defendant is responsible for all damages. It does not matter if defendants act in concert or in conspiracy, nor does it matter if each of their cause is sufficient to cause harm. Multiple sufficient causes are not needed, and the plaintiff can sue two or more tortfeasors and recover damages such as the entire amount from any defendant she chooses, as long as the defendant was a cause of her injury. It can be one or both in which would have to pay. And that is joint liability and contribution. So, with regards to contribution, one defendant can sue another defendant who paid nothing to get their fair share back. That's done in a cross claim in the same claim to not waste money. This is a claim for restitution brought in an action for contribution. And then there's several liability. The damage of a negligent act can be separated And that's pretty much the definition of several liability. But let's get into the definition of remittitur, and that's spelled Remittitur. So the plaintiff gives back a portion of damages to the defendant. It is moved for by the defendant. There are arguments about if it would be granted or not. Then the judge may approve or deny. And that wraps up our negligence section. With regards to American law torts, there are apportionment of damages to consider. And they include vicarious liability, respondeat superior, also things like the purpose test, the characteristics activities test, and then direct liability, and then joint liability and contribution. So under apportionment of damages, vicarious liability rule is the suit against the company or organization when its member offended the plaintiff. When one person or entity is held responsible for the tortious acts of another who is acting on her or its behalf. So respondeat superior, this is where the employer is subject to liability for tortious conduct done by the employee. The employee is without blame, the employer is without blame or fault. The torts committed by the employee is within the scope of employment. This creates a form of strict or no fault liability. And this was found in the case of Tabor v. Maine in 1995. So there's two things that you need. One, the employer's right of control of the employee, and two, the scope of employment. Was the plaintiff acting within the job description? Is a question that must be answered. So there is an exception to respondeat superior under vicarious liability under the element of apportionment of damages. So the exception is independent contractors. Independent contractors are not subject to vicarious liability unless the contractor is engaged in inherently dangerous activities and non-delegable duties. Well, let me restate that. The employer is not subject to vicarious liability unless the contractor is engaged in inherently dangerous activities and non-delegable duties. These obligations, when it says non-delegable duties, it means these obligations cannot be delegated to the public due to stipulations of public policy, statute, or common law. And essentially that means a business cannot pass off the duty to maintain the premises onto another. That is non-delegable duty. An independent contractor is one hired to accomplish a task or result, but who is not subject to a right of control by the employer. So there are rules to the scope of employment to determine if, respondeat superior can be used. So the rules to the scope of employment include the purpose test and the characteristics activities test. So the purpose test is the older, more general version of respondeat superior. It's where the careless acts are within the scope of employment if the employee acted at least in part for the purpose of advancing the employer's interests. So the characteristics activities test is specific to California. It's the modern version of respondeat superior. Careless acts within the scope of employment where act is said to be characteristic of employer's activities. And the company culture is part of this. Again, that is the characteristics activities test to determine if respondeat superior would apply. And there are exceptions, sort of. Intentional torts have generally no vicarious liability under the purpose test. There is an exception, however. There isn't an exception after that exception. So there usually is vicarious liability if there is force inherent in the employee's work. This is also present under the characteristics activities test. So just to put that together a bit smoothly, intentional torts generally have no vicarious liability under the purpose test. However, if force is inherent to the employee's work, then there may be vicarious liability. So the exceptions continue is if the employee detours from their usual scope of employment, then there may be possible vicarious liability. And if the employee frolics, um, if it's like an unauthorized and substantial deviation from the scope of work, then generally there is no vicarious liability because the frolic was unauthorized and it was a substantial deviation from their scope of work. And with regards to detour, like say for example, if the detour is minor and it's a permissible deviation from the scope of employment, then there is possible vicarious liability. So let's get into direct liability, and then we're going to close with joint liability and contribution for apportionment of damages. Direct liability, the employer wronged by failing to screen or supervise employees, and this wrongful conduct helped to bring about the plaintiff's injuries. That is direct liability. The employer and the employee would be held jointly and severally liable to the plaintiff for the employee's actions within the scope of employment. And then we'll end with joint liability and contribution. It basically answers the question, who is paying what for the damages and how much is it? Two or more actors already found guilty of the torts, usually against one plaintiff, and each have to be seen as actual and proximate cause. So when it comes to joint liability and contribution, it happens after two or more actors have already been found guilty of the torts, usually against one plaintiff, and each actor has to be seen as actual and proximate cause of plaintiff's injuries. Okay, so property torts center around trespass, different types of trespass for different reasons, as well as nuisance, public and private nuisance. So trespass, the common law definition is matters not if the actor who invaded took reasonable care to prevent it. It matters if the actor set out to make or remain in contact with the land, and if the actor did make or remain in contact with the land. The interference of the property right of another does not have to be reasonable. So trespass to land, invading a possessor's interest in exclusive use of the land. One step onto the land with a quick retreat is trespass. Physical harm is not needed. The plaintiff must have ownership and control of the real property, and the defendant must intend to occupy or cause physical invasion of that real property. Trespass to land is strict liability. The defendant must intend to be there, and the plaintiff does not have to prove the defendant had intent to trespass. Trespass tort is strict liability because the defendant must only intend to be there and not intend to trespass. Reasonableness is not needed for the trespass. The trespass defense is consent of the plaintiff to the defendant. Silence alone is not consent. Consent is restricted by time or location. Consent is a fact issue for the jury to decide. Consent can be implied by behavior, accommodating the traveler, or verbal. So consent can be implied by behavior, for example, accommodating the traveler, or consent can be verbal. Consent cannot be redacted without the defendant's knowledge. So there's a defense of necessity to trespass. The defendant will not be held to pay damages if they had to trespass. The defendant is not a trespasser. The plaintiff can sue for other claim to recover for damages. Punitive damages are typically not available. Necessity and inability to control movements begin the proper exercise of a strict right, justify entries upon land and interference with personal property that would otherwise have been trespasses. Trespass and necessity. The rule is whether, and if so, why an actor can be held liable for invading another's property despite that the invasion was undertaken out of necessity. So there's public necessity. So the rule is the public necessity privilege protects individuals from liability. So whether the relevant governmental bodies bear any legal or moral obligations to compensate persons whose property is sacrificed for the public good, it is answered yes. And this was found in the case of U.S. versus Russell in 1871. So in U.S. versus Russell, the court is of the opinion that the employment and use of the steamboats were such as raise an implied promise on the part of the United States to reimburse the owner for the services rendered and the expenses incurred. So conversion and trespass to personal property or chattels. So conversion is intent and modes of interference, and it's understood by two and a half elements. So the first element is intentionally interacting with personal property lawfully possessed by another in a manner that is inconsistent with the other having superior possessory rights in that item, and through such interaction completely depriving the possessor of possession or causing an interference with possession. Also, that act, the interaction must be so substantial as to warrant the possessor in treating it as a complete deprivation. Conversion is the civil version of theft or larceny. So, conversion, it's not regarding to real property, but just personal property. Other defenses to property torts are privileges to enter or take property, entry incidental to the use of a public highway or navigable stream, entry to reclaim goods, entry to abate a private nuisance, and entry in order to effect an arrest or otherwise prevent crimes. The issue is pay close attention to the scope of the privilege and conditions of its exercise and to the possibility that it has been abused. Utility of risk. So this is under utility of risk, like what's the usefulness of the risk of possibly committing a trespass or property tort? The plaintiff must prove the risk is the plaintiff must prove the risk of using. Oh, hold on. Okay, so that is trespass with regards to property torts. Let's get into nuisance. So, with regards to nuisance, it's kind of trespass. The rule is, with regards to trespass, it protects and vindicates the right to exclude persons, objects, and substances from one's property. This is when the acts interfere with the use and enjoyment of property and can occur even absent physical invasion that is necessary for a trespass suit. So that is the essence of nuisance, is the kind of trespass. So nuisance is non-invasive interferences with property rights are tortious. And so the rule for nuisance is the act that causes interference with the right to use and enjoy another's real property. It must be intentional and unreasonable. If it is reasonable, then see if it is intentional. The level of intent for nuisance is not needed. Can negligent or reckless conduct, cause the nuisance? Negligently or operated nuisance may cause a nuisance. If the act is abnormal or out of place for the surroundings to the level of strict liability for abnormally dangerous activities and ongoing interferences with another's right to use and enjoy real property. And we just have to put in telemarketers are not nuisances in a tortious sense. So just to clarify, a nuisance can be negligent or reckless conduct. A nuisance can be caused by negligence or by an operated nuisance. There are further exceptions to what can be considered a nuisance: noisy racetracks, low flying air traffic, howling dogs, pollutants, animal farm in a non rural setting, bright lights in a residential neighborhood, structures that block another's access to air or light. Factors relevant to reasonableness include nature of the interfering use and the use and enjoyment invaded, nature of the extent and duration of interference, suitability of locality of both interfering conduct and particular use and enjoyment invaded. And the issue is basically whether the defendant took all feasible precautions to avoid any unnecessary interference with plaintiff's use and enjoyment of the property, and when other relevant factors exist that interfere with a person's that interferes with a person's use and enjoyment of their property. And these are factors relevant to reasonableness. And so the case that really illustrates this is Sturgis v. Bridgman. This is where it was a doctor, Dr. Sturgis, versus a candy maker named Bridgman. The Dr. Sturgis won. Brigman's weaker defense was that Sturgis came to the nuisance. This is when a candy maker was making taffy in his house by pounding taffy with huge mallets. And the doctor had a pediatrics office attached to his home that was newly built, but it came very close to the noise of the taffy being created that was very loud. And so, the Bridgman, the candy maker, said that the doctor came to the nuisance, but really that was a residential area, and loud industrious noises such as pounding the taffy to make the candy were not, legally allowed anymore since someone complained about it. All right. Now let's go into private nuisance. The rule is to protect the interest and possessor's use and enjoyment of their land. That is the policy. So with regards to the public nuisance, the rule is it protects interests common to the public: safety, comfort, public convenience, and public health. Individuals cannot bring a public nuisance claim, and this was found in Boomer v. Atlantic Cement Company. And the nuisance defense is if someone comes to the nuisance, like in the case of Sturgis v. Brigman, that is a defense to the nuisance. Or another defense is it is reasonable to cause the disturbance. The remedies for private nuisance include, in regards to Boomer v. Atlantic, Boomer is a citizen with polluted land by Atlantic Cement Company. A temporary injunction was given to Atlantic Cement because a permanent injunction meant the economic benefit of keeping the factory open was greater than the harm suffered by Boomer. And the award was an injunction was lifted once Atlantic paid permanent damages to Boomer. And so with regards to permanent injunction, temporary damages, and permanent damages, those are all remedies. So permanent damages can be related to damages such as compensatory and or punitive damages. Temporary damages can be related to self-help. And then permanent injunction is basically just an injunction. Yeah. Now we're going to dive into strict liability torts, which include wild animals as well as domesticated animals, torts related to abnormally dangerous activities as well as their causation, and lastly, products liability. And we will also go over risk utility test and consumer expectations test. So when it comes to wild animals, this is just an overview. It's regarding trespassing. In reference to domesticated animals, it really depends on if there was a history of a propensity for harm and danger. An exception to this is if a dog bites you, the owner is strictly liable whether it has a history or not. And now under abnormally dangerous activities, there are 6 factors which we will go into, but they all center around whether the act is abnormally dangerous or not. And then the causation element for abnormally dangerous activities under strict liability torts is the court decides, if a abnormally dangerous activity was the cause of the harm. And then products liability, it starts with the prima facie case of a products liability tort, which includes four main elements to include the plaintiff must suffer an injury, the defendant sold the product, the defendant is the seller, and the product is defective either by manufacturing defect, design defect, or failure to warn. And then there's certain tests to determine liability, things like risk utility test. They don't go into, there's the risk utility test, and then there's consumer expectations test. Consumer expectations test is a defect. Well, I shouldn't say a defect, but consumer expectations test is usually a bit more tricky to prove because consumers' expectations can differ depending on how you use a product. Sometimes one product can be used multiple ways, like Dawn dish soap. It can be used to wash dishes, or it can be used to, clean up after an oil spill. And so the fifth element with regards to product liability prima facie case is the defect was actual and proximate cause. So that was a summary of the different types of strict liability that we will be studying. So the policy with regards to strict liability torts is it prevents certain types of dangerous harms from happening. The fault or intent is not needed. The definition of strict liability is liability without fault. It imposed on the defendant regardless if they were negligent or culpable, even if they went above and beyond to prevent incident from happening. It appears in abnormally dangerous activities, products liability, cases involving dangerous animals. Damages can be mitigated for the plaintiff if the defendant did nothing wrong. Strict liability applies in keeping of wild animals, trespassing livestock, domesticated animals with known dangerous propensities by the owner, not liable for injuries unless you have knowledge of animals' dangerous tendencies, abnormally dangerous activities, and defective products. So with regard to the possessor of animals, strict liability is applied in these following ways. A wild animal is an animal that is not traditionally domesticated. Domesticated animals, except for dogs. So the exception for dogs is one dog bite and the owner is liable with or without history of dangerous propensity to bite or injure. So farm animals liability is based on trespass. Possessors of livestock who trespass and cause property damage are subject to strict liability. And basically when I say possessors of livestock who trespass, I'm talking about the animals trespassing, not the person, not the owner. And livestock is defined as animals that are raised as part of a farming or ranching operation, including animals raised for meat, milk, eggs, wool. Dogs and cats are not livestock. And the harm must be within the scope of risk. So the trespassing farm animal, the harm that they cause must be within the scope of risk. So let's give an if-then statement. If the incident is outside of the scope of risk, then the owner is merely liable under negligence law and not strict liability. An example, a bear falls asleep on the road and a driver hits it and causes damage to their vehicle, and the injuries are to the passenger and the driver. The owner of this domesticated bear, or this bear that they raised in the house, is only subject to negligence and not strict liability, because the scope of risk of a bear is being mauled to injury or death, not sleeping on the road and causing damages to your vehicle and to the inhabitants of the vehicle. So domesticated animals usually require negligence. An exception is for the dog bite statute. And so products liability. So actor A is subject to liability to person P if products liability is proven by finding the following elements to be present. The plaintiff has suffered an injury. The defendant sold a product. The defendant is commercial seller of such products. At the time it was sold by the defendant, the product was in a defective condition, and the defect functioned as an actual and proximate cause of plaintiff's injury. So products liability theories to sue under: manufacturing defect, product diverges from the manufacturer's own specifications for the product. Design defect, a flaw in the plan or specifications for the product. The flaw or flaws alleged may be small or technical, or may go to the essence of the product. This is the most common one. And then there's failure to warn. This is where safety requirements that the product be sold with a warning, but the product is sold without a warning or without an adequate warning. If it's sold without a warning, then the product is per se defective. If it's sold with a lack of warning, so lack of warning is a warning or product defect. So there are three types of warranty rules. There's express warranty, implied warranty of merchantability, and implied warranty of fitness for a particular purpose. So under express warranty, this means the retailer or manufacturer's guarantee by words or pictures about products' certain qualities. That is express warranty. Implied warranty of merchantability is reasonably suitable for ordinary uses for which goods of that description are sold. That is implied warranty of merchantability. And then there is implied warranty of fitness for a particular purpose. This is where the buyer relies on the seller's skill or judgment selecting goods. That is implied warranty of fitness for a particular purpose. So the tests for design defect, there is a consumer expectations test, as well as the risk utility test. So the consumer expectations test, test is if the product fails to perform as safely as an ordinary customer would expect when used as intended or reasonably foreseeable manner. So the risk utility test is where the plaintiff must prove the risk of using the product outweighed by its utility. A product is defective if a reasonable person would determine that the probability and seriousness of harm that the product will cause actually outweighs the burden or costs of precautions. The elements are dispositive. It is the rule and it is not persuasive. So let's just, put some names to this. The company Apple prefers the risk utility test to be applied because people will buy the product anyway. If the utility of the product outweighs the danger inherent in selling the product, for example, bleach. Bleach it can be dangerous. It depends on how you wield it and who's using it. But the risk utility test, it does determine if the utility of the product outweighs the danger inherent in selling the product. Bleach is inherently dangerous, but its utility to kill germs and things like that outweighs its propensity or its potential for danger. At the time it leaves the seller's hands, is the product in a condition not reasonably contemplated by the consumer and is unreasonably dangerous for its intended use. That's something that you have to determine when you apply the risk utility test as well. So let's give an if-then statement. If the utility of a product does not outweigh the danger inherent in the introduction into the stream of commerce, then the product is defectively designed. This was the case with regards to the red devil dye. And when I say utility, I mean the usefulness of the item. Bleach is useful, lye is useful. It's just if the usefulness of a product does not outweigh the danger inherent in the introduction into the stream of commerce, then the product is defectively designed. It's possible to create a very effective product, but that's just too darn dangerous for the public to use. So the purpose of the risk utility analysis is to just parse some things out, just to organize facts in the case. Even with adequate warnings, a product may be so dangerous and misuse may be so foreseeable that the application of the risk utility test could conclude that the utility or usefulness did not outweigh the risk inherent in marketing. And this was found in Denny v. Ford Motor Company in 1995. So the relevant information to the risk utility analysis is it has to be, useful or utility to the public, useful or provide utility to the user. What also is relevant information to the risk utility analysis is likelihood of injury, available, safer design, possibility of designing and manufacturing a product to make it safer and remain functional and reasonably priced, degree of awareness of potential danger that can reasonably be attributed to the injured user, and the manufacturer's ability to spread the cost of any safety related design changes. One note that I would like to make is most courts use this test, the risk utility analysis test. It's more precise than the consumer expectation test. And now there is a design defect claim. For recovery, a plaintiff needs that the product was in defective condition at the time it left the seller, unreasonable, dangerous to user. Defect was a cause of injury, actual and proximate. Product was expected to and did reach the consumer without substantial change in condition. Alrighty, so there's warning defects claim. The two functions of warning in products cases is one, to allow user to make an informed decision about whether to use the product in the first place, and two, instructions that inform users how to use the product safely. And this requires expert testimony. So what is a warning? A warning must do three main things. It must be designed so it can reasonably be expected to catch the attention of the consumer. It must be comprehensible and give a fair indication of the specific risks involved with the product. And it must be of an intensity justified by the magnitude of the product. And this was found true in Lewis v. Sear Ray Boats Incorporated. The manufacturer, in other words, the manufacturer must ask, what would I suffer if I don't disclose the risk? So product's liability. A product is defective because of inadequate instructions or warnings when the foreseeable risks of harm posed by the product could have been reduced by the provision of reasonable instructions or warnings by the seller, the omission of which renders the product not reasonably safe. So with regards to strict liability, who has the duty to warn? And with regards to product liability, commercial seller has the duty to warn. To whom is the duty owed? The duty is owed to the purchaser and the user. And when is the warning needed? The warning is needed for non-obvious risks. What must the warning do? It must adequately identify type and severity of risk. The adequacy factors for warning include prominence. Where is the warning located? Accuracy. Which risks is it trying to tell the purchaser or user? Clarity. Is it explained in words or symbols? A product is defective with a failure to warn if the seller fails to provide safety information to members of those classes of persons who should be alerted to the relevant risks associated with the product in an adequate manner. So classes of people do not include drug abusers, children, people taking prescription drugs without a prescription. So effect of product warning on design defect claims. So basically, the product warning provides that manufacturers could assume that product warnings would be heeded and that products with adequate warnings were not defective. When it comes to products liability, when a safer design is reasonable, adoption of the safer design is required over a warning that leaves significant risks. A product's warning is only one factor a court should take into account in deciding whether a design defect exists under a risk utility test. So why the product is defective under strict liability regarding warnings? Well, it's because that they are design defects. If there is no warning, it's a design defect. That's one claim. But if there's a failure to warn, such as no warning or no adequate warning, then that's a second claim. So another claim is there was no warning or the warning was inadequate, which left me injured. Another claim is these are based on the same nucleus of facts. So there's, if there is no warning, it's a design defect. And if there was a failure to warn, then that's when there is no So failure to warn is when that there is no warning and or inadequate warning. Those are two different claims. and they're based on the same nucleus of facts. So, what is needed to prove or disprove a strict liability products liability case? State of the art evidence is needed to prove design defect regarding warning claim. The state of scientific knowledge at the time the product was manufactured and sold, the modern version of custom. That's what that's describing. So there's the state of the art evidence. That's pretty much the modern version of custom. And then state of the art evidence prevents ambiguity. So the level of relevant scientific, technological, and safety knowledge existing and reasonably feasible at the time of design will be a factor in determining what's needed to prove or disprove a strict liability, products liability case. So state of the art evidence is admissible, not determinative. Compliance with the state of the art is not necessarily a defense. So basically, how does this look in action? What's the dialogue here? So the argument is where the plaintiff says the defendant knew the danger, but the defense is where the defendant says we did not know the danger. And this is where the defendant gives the state of the art defense. This knowledge was not known at the time of manufacture and sale. However, the argument is where the plaintiff says knowability is a factor to hold defendant liable. You had the ability to know with the technology at the time. Therefore, the state of the art defense is weakened. This is for non-obvious dangers. So the next part of strict liability is abnormally dangerous activities. When someone's, acting in a form of abnormally dangerous activities, then strict liability will likely apply. So abnormally dangerous activities, the rule is, the factors to be weighed in deciding whether an activity is abnormally dangerous. These are the questions of law for the court to determine, not for the jury to determine. So a couple of elements needed to see if an activity is abnormally dangerous to incur strict liability is there a high degree of risk? The gravity of resulting harm? Whether risk can be eliminated by exercise of reasonable care? Is it not a matter of common usage? Is it inappropriate to the place that the activity was carried on? Is the value of the activity to the community worth it? So activities create foreseeable and highly significant risk of physical harm even when reasonable care is exercised, and activity is not a matter of common usage. Examples of abnormally dangerous activities that would incur strict liability are things like blasting, oil drilling, fireworks, explosives, so on and so forth. And that concludes our strict liability portion of the study of torts. Intentional torts overview. Intentional torts include torts like assault, battery, false imprisonment, intentional infliction of emotional distress, misrepresentation, things like that. So under battery, the reason why battery is a tort is because the law wants to protect bodily integrity. Elements of battery are intentional acts, attempts to make contact harmful or offensive. The plaintiff actually suffers harmful or offensive contact. Defenses include, the defendant can say that they had the plaintiff's consent, either express or implied. The defense or the defendant can say that it was an act of self-defense, but in order for that to be believed, the act of defense has to be reasonable force and defense of others and property, such as real property. The counter arguments, the defendant can say, I did not intend to harm, but the plaintiff says, all I need to prove is an attempt to make contact, and the jury determines if the contact is offensive. So that's battery. So under assault, it's the right to exist without fear is the reason why assault is a tort in American law. The elements to assault are intentional acts to intending to cause apprehension, which is a belief of imminent harm or offensive contact. The defendant's act causes plaintiff to reasonably apprehend the contact. This is subjective and objective. Defenses include consent, self-defense of others, and property. Then there is false imprisonment, and this is to protect freedom of movement. The reason why false imprisonment is a tort is for that reason, to protect freedom of movement. And the elements are intentional act to confine freedom of movement of plaintiff, causes plaintiff to be confined. Plaintiff is aware that they're confined. And then there's something called shopkeeper's privilege. That is a defense. Shopkeeper's privilege includes that the shopkeeper must reasonably believe. They must hold the plaintiff for a reasonable amount of time. The shopkeeper must reasonably believe that the plaintiff is stealing or is in the process of stealing. They must hold them for a reasonable amount of time in a reasonable manner. And a reasonable mistake is okay. Like, say, for example, the plaintiff wasn't actually stealing, a reasonable mistake of them stealing is okay. And detention is within or near the store, and their acts must not cause death or serious bodily injury. A defense to false imprisonment is consent, self-defense of others, and property. Then there's intentional infliction of emotional distress, intentional act, extreme and outrageous intent with a reckless disregard to cause severe emotional distress. Actual and proximate cause, it is a matter of fact for the jury. Misrepresentation is a misrepresentation of facts. It's represented, the representation is susceptible to knowledge, liability for misrepresentation of opinion. False statements of opinion may result in liability. Misrepresentation of law is statement of opinion on which no one has a right to rely on, but the statement may imply the existence of external facts, so on and so forth. So intentional torts are torts that require the defendant to intentionally commit the elements that define the tort. Examples, again, are battery, assault, false imprisonment, intentional infliction of emotional distress, and misrepresentation. The intentional tort of assault protects individual bodily integrity, the right to exist without fear, protects against apprehensions of contact, where no actual contact is made. The prima facie case elements are defendant is liable to plaintiff for assault if the defendant acts intending to cause plaintiff to perceive an imminent harm or offensive contact, and the defendant's act causes plaintiff to reasonably perceive that such contact is going to happen. This is subjective and objective. If the plaintiff can't see the defendant, then there is no assault because plaintiff could not apprehend or perceive. An exception is conditional threats are not assault. That's to say, if you don't pick up the phone, I'm going to slap you across the face. I'm tired of hearing it ring. That's not assault. That's because a slap across the face would occur if a person doesn't pick up their phone as it's ringing. So let's just draw a difference between apprehension and fear because they're not the same thing. Apprehension is awareness that the contact could occur, perception of offensive or harmful contact, and again, it's not the same as fear. Fear is an unpleasant emotion caused by the belief that someone or something is dangerous and likely to cause pain or a threat. With regards to intentional tort, it's very good to go over the definition of intent. In most courts, a person acts with intent to produce a consequence if the person acts with purpose of producing that consequence, or the person acts knowing the consequence is substantially certain. The defendant desires or purposes the result or knows a substantial certainty. The subjective elements are the defendant's state of mind is key. The issue is, did the defendant desire outcome or know to a substantial certainty that it would occur? The strategy is to rely on circumstantial evidence for proof of intent. If we don't have facts about defendant's state of mind, then we lean on the reasonable person standard. Proof of intent. Direct evidence usually is not available. The use of circumstantial evidence is what you would go to, and motive is not intent. So let's give an if-then statement. Did the defendant have the intent to harm or offend? If no, then there is no intent and therefore no tort. However, did the defendant have intent to harm or offend? If yes, there is intent and therefore at least one tort. With regards to the element of intent, you need intent to cause contact that is harmful or offensive. So let's go to intent. Let's revisit that transferred intent. So transferred intent fills in the gap mismatch between intent and consequence. The transfer of intent between torts. The actor intending assault is liable for battery if harmful or offensive contact occurs. If imminent harmful or offensive contact occurs, then the actor intending battery is liable for assault in apprehension. The transfer of intent among people. So say, for example, with regards to transfer intent among people, one who acts intending to batter or assault one person and batters or assaults another person is liable to the other person for the invasion the person suffers. So intent and knowledge to a substantial certainty. Battery is an intentional tort. Intentional torts are subjective standard. The defendant must know to a near certainty that conduct will produce the requisite result. Let's dive deeper into battery. Battery, intentional, harmful, or offensive touching. Battery elements are an act, an intentional act, and harmful or offensive contact, which is subjective and up to the jury. So the battery breakdown is the defendant is subject to liability to plaintiff for battery if the defendant acts intending to cause a contact with the plaintiff or a third person, volitional. The contact with the plaintiff, a specific person that defendant intends, is of a harmful or offensive type. And the defendant acts causes plaintiff to suffer a contact that is harmful or offensive. You don't need intent to hurt. You only need intent to make contact. That cannot be stressed enough. The defendant can be liable if the defendant intended to put plaintiff in imminent anticipation of offensive contact. So battery, harmful, or offensive touching, indirect contact is enough. So harmful contact, physical injury. Harmful contact includes contact that causes physical injury, pain, or illness. Offensive contact, the key is offensive to an ordinary person, is not unduly sensitive. This is the objective standard. The different sources use use a different formulation for this standard. For example, violating prevailing social standards of acceptable touching. So there's many different ways to define offensive touching. Another example is offends a reasonable sense of dignity. There are no magic words to determine if the offense is acceptable or not, or what the formulation of the standard of offensive to an ordinary person. So a trivial amount of physical contact may be enough. So the indirect contact may be enough. No physical contact between plaintiff and defendant is needed. For example, shootings, dog attacks, things of that nature. Contact with things connected to plaintiff's body. This was definitely found in the case of Fisher. It includes extended personality. So the purpose of battery tort is to protect bodily integrity. And just to throw something in, wrongful death, this is not a type of tort, but it is an action that one can bring once the tort has been proven. So defenses to battery, consent. Definition of consent is party that suffered harmful or offensive contact agreed to suffer that contact. There are two types of consents, express and implied, and we'll go into that deeper later. Consent is a justification, not negation of liability. This is a justification to battery and not a negation of battery. Implied consent is measured objectively with regards to reasonableness. A tortfeasor can't benefit from the consent defense if the defendant secured the victim's consent by misrepresentation or other forms of deceit. Express consent. Consent is expressly stated either in a writing or by oral statement. For example, a surgical patient, say for example, you go into surgery for your right ear. The doctor notices that there's something going on with your left ear too, but you're only consented to surgery on the right ear. The surgeon takes liberties in messing with your left ear too in the surgery, and you can claim battery for that, but the jury's going to decide if it sticks. So you can't secure consent with deceit or misrepresentation. So implied consent, voluntary participation in contact sports. Contact would otherwise might be tortious. For example, a person who enters a crowded train will be said to have consented to at least some intentional caused contacts, like being pushed by another onboarding. Standard defenses to battery and assault, self-defense, and defense of others, defenses to battery. So self-defense is the reasonable force where one reasonably and sincerely believes force is necessary to protect oneself from imminent or immediate harm. Objectively and subjectively determined, defendant's belief is subjective. The defendant, in fact, believe harm was imminent, and it's also objective. So defense of others, privilege to injury, to defend a law, defense of others, privilege to injure, to defend others as long as defendant actually and reasonably believes that injury or injuring plaintiff is necessary to avoid an imminent injury of the requisite type to one or more third parties. Defendant is privileged to use proportionate force against plaintiff to prevent such injuries. In contrast, necessity of sparing oneself from injury is generally held insufficient to excuse the injuring of an innocent third party. So, for example, if X were to grab an innocent bystander to shield them is not excusable. Defense of property. Property isn't a person. You cannot defend property like a person. Insanity is generally not a defense to intentional torts, public necessity, or the use or destruction of property for public benefit, not acting against persons who threaten harm to others, is another defense to battery. So recapture of property. Privilege to use reasonable force to defend property applies only preventatively. If property momentarily occupied by an intruder, then the owner may act, but only with reasonable force. So the recapture of property continues by saying, basically recapture of property is when another takes personal property or chattel by force. The owner can use reasonable force within a reasonable time to recapture the chattel. The owner must ask the chattel taker to return the property before using reasonable force, unless it would be useless or dangerous to do so. Here's a note. The reasonable time requirement is a jury decision. The intruder who has no right to be there, the owner may use reasonable force to remove him. By contrast, if the owner were forcibly to evict a person who is not entitled to occupy land, yet who enjoys peaceable or not transitory possession of it, expired lease is an example of that, the owner risks criminal penalty and possibly tort liability to the wrongful possessor, even if the owner's force is reasonable. Now let's get into false imprisonment. The policy is, this is to protect the rights to physical freedom. False imprisonment elements include willful detention by the defendant without consent of the detainee and without authority of law. Detention may be by violence, threats, or by any other means to restrain from moving from one place to another. Factors for sufficient threats to overcome plaintiff's free will. The factors for sufficient threat to overcome plaintiff's free will are the participant's relative size, their age, their experience, their sex, and their physical demeanor. Affirmative defenses to false imprisonment include consent and authority. False imprisonment prima facie case protects freedom of movement. The confinement must be complete. If there is a reasonable way to escape, then you are not confined. So actor D is subject to liability to P for false imprisonment if the defendant acts intending to confine the plaintiff a specific person. Defendant act causes plaintiff to be confined, and the plaintiff is aware of her confinement. So what counts as confinement? Defendant caused plaintiff to be within a bounded physical space, movable spaces included, denied access to exit without significant risk of physical harm to himself or others. The plaintiff reasonably believes that the defendant will seek to prevent plaintiff from leaving. Other forms of pressure, even if plaintiff is literally free to move. Other forms of pressure examples are taking of children or property if the plaintiff leaves. Lesser constraints on exit, like such as loss of reputation or embarrassment if they leave. Threats of certain consequences not pertaining directly to the confinement, like termination from job or persecution, are generally not included. The exceptions, these don't count as false imprisonment. A very large space like a country, travel restriction, absent special circumstances, minimal inconvenience, no expectation that exit will be resisted. Awareness of confinement. The plaintiff must prove she was aware of confinement as it happened. Sleeping and being an infant mean that they were not aware of confinement as it happened. This may bar recovery from people who later find that their confinement was unlawful. Willful versus accidental confinement. By a preponderance of the evidence that defendant acted for the purpose of causing confinement or with knowledge plaintiff would be confined. Confinement out of misunderstandings is not false imprisonment, but actor may be liable for negligence if plaintiff is harmed. Defenses to false imprisonment. Consider defenses only after addressing the prima facie case. Express consent, implied consent, self-defense, defense of property, authority of law such as shopkeeper's privilege. Now let's go into shopkeeper's privilege. It's detention, a reasonable belief a person has stolen or is attempting to steal, detention for a reasonable time, and detention in a reasonable manner. Shopkeeper reasonably believes another has or attempting to steal property is privileged to detain in a reasonable manner and for a reasonable time to investigate ownership of the property. Reasonable mistakes do not defeat the privilege of the shopkeeper. Detention must be within or near the store. Never allow force intended to inflict death or serious bodily injury. Okay, intentional infliction of emotional distress. Protection of dignitary interest. An actor could be held liable for conduct that is extreme or outrageous beyond all bounds of decency. That's determined by the jury. Intent with reckless indifference that would likely cause harm. It helps your case if the emotional distress is so severe that it could be expected to affect adverse physical health, and actual and proximate cause of plaintiff's severe emotional distress, even if distress does not actually generate the expected physical harm. The harm does not have to be foreseeable. These claims are rare to succeed. Cases include Nickerson v. Hodges. This happened in 1920, where there was a fake pot of gold buried, said to a woman known to have a mental infirmity. So basically, these people tricked this woman who had a known mental infirmity that there was a pot of gold buried on some land. And so they actually took some type of container and filled it with dirt and buried it. It was basically a fake pot of gold. The container wasn't open until days later at a bank when the woman thought, the bank would be the best place to hold the pot of gold. When they opened it up, it was just dirt. And that was considered intentional infliction of emotional distress. Another case is Wilkinson v. Downton. This happened in 1897. This was an example case where there was a cruel joke made to a woman at her home. So basically, this man walked up to this woman's house with her husband there, knocked on the door, and he made a cruel joke saying that her husband was horribly injured in a car collision and that she had to come down to the hospital. And so that was considered intentional infliction of emotional distress. So threats for future harm are actionable. This was in the case of Dickens v. Puryear. If the statute of limitations has been surpassed for assault and or battery, then any intentional infliction of emotional distress anchored to that assault and battery is not enforceable per Dickinson. In North Carolina and other jurisdictions, may not recover, or a plaintiff may not recover for fright alone, but for physical harm like a heart attack. There is also negligent infliction of emotional distress. It's not necessarily, there is negligent infliction of emotional distress. Pretty much is, intentional infliction of emotional stress is the focus of this section, but to do so negligently, recklessly, that's another type of another type of infliction of emotional distress. So the bystander intentional infliction of emotional distress. This is distress to a member of such person's immediate family who was present at the time, whether or not such distress results in bodily harm, or another person who is present at the time if such distress results in bodily harm. And just to clear things up, negligent infliction of emotional distress is not necessarily intentional. Only intentional infliction of emotional distress is intentional. Negligent is well, I had bad judgment there, okay. But I didn't intend to cause infliction of emotional distress. So let's get into misrepresentation. There are two types of misrepresentation torts: fraudulent misrepresentation and negligent misrepresentation. Fraudulent misrepresentation requires a false statement of fact that is made with knowledge or reckless disregard to its falsity and intended to induce the victim's reliance, provided the victim actually and in some jurisdictions reasonably relies on the misrepresentation and suffers damages as a result. False statement of material fact. The actor must make a false statement of past or present material fact. A fact is material if it is reasonably likely to affect the victim's decision on the subject matter of the fraud, or else if the actor knows that the facts will affect the victim's decision reasonably or not. The subjective opinions not actionable. A statement of fact is an assertion that can be proven true or false. Subjective opinions and exaggerated boasting, sometimes called puffery, about quality, value, and other matters of judgment are not statements of fact. An opinion may be actionable as fraud if the supposed opinion states or implies objective facts. A professional or fiduciary, such as a lawyer, knowingly conveys a false legal opinion to one whom the professional or fiduciary owes a duty to convey honest opinions, and knowingly false opinions by one with special or superior knowledge of the subject matter of a transaction between the parties. A broken promise is generally not actionable in tort. That the actor broke a promise does not turn the promise into a false statement of fact. However, there is a promissory fraud exception if the actor had no intention of keeping a promise at the time he made the promise. Then the promise can be actionable as a false statement of the fact of the actor's present intent to do what was promised. Predictions are generally not actionable. Predictions of future events are not statements of past or present fact, so they are generally not actionable in misrepresentation. Yet this rule assumes that the prediction is an honest reflection of the actor's belief in the prediction. If the actor knows or believes present facts that make the prediction impossible or improbable, then she may be liable for falsely representing her present state of mind. Non-disclosure generally not actionable as a tort. The mere failure to disclose a material fact is generally not a false statement. Exception is a duty to disclose. If the actor has a legal duty to disclose material information to the victim, failure to disclose may be treated as a false statement. A fiduciary relationship. If the actor owes the victim a fiduciary duty, the actor must disclose material information. For instance, partners in a partnership generally owe each other fiduciary duties concerning partnership, business, and property, and professionals like lawyers often owe their clients fiduciary duties. Facts peculiarly within actor's knowledge. The actor may owe a duty to disclose material information if the actor and the victim are parties to a transaction. The actor knows that the victim is mistaken about a basic factual assumption underlying the transaction, and the victim would, under the circumstances, reasonably expect the actor to disclose this information. An example of this would be a prospective buyer of a house had a reasonable inspection performed on the house. The inspection revealed no defects, yet the seller knew that the house had serious structural defects that most reasonable inspections would miss. Here, the seller must inform the buyer of the defects of or risk liability for intentional misrepresentation. The seller and buyer were parties to a transaction, and the seller knew of the defects and how a reasonable inspection would likely miss them. Of course, any reasonable buyer of real estate would expect disclosure, of serious latent defects. Actor creating false impression. If the actor knows or should know that his words or actions were deceived, if an actor knows or should know that his words or actions have deceived the victim or created a false impression, then the actor must disclose enough facts so that the victim is no longer materially misled. The situation often arises if the actor conveys half-truths or only partially discloses material facts, and the half-truth or partial disclosure materially misleads the victim. The situation may also arise if the actor's statement is true when made, but the actor later learns that the facts have since changed, such that the statement is no longer true. Here, the actor must normally disclose the intervening events to the victim. Active concealment. If the actor actively conceals material facts with intent to deceive, the concealment will be treated as a false statement. Active concealment generally involves intentionally hindering the victim from discovering material facts, as by hiding them or covering them up to induce or facilitate a false belief by the victim. For instance, when selling aluminum sheets might stack good sheets on top to hide corroded sheets beneath. Knowing or reckless disregard. The actor must make the false statement of fact with either knowledge or reckless disregard of its falsity. Intent to induce reliance. The actor must induce the victim to rely on the false statement of fact. Here, inducement means that the actor intended the reliance, or else the actor could reasonably foresee reliance by someone in the victim's position. Of course, multiple parties might foreseeably rely on a given fraudulent misrepresentation, but put another way, the actor's misrepresentation of material fact must be an actual cause of the victim's financial harm. Actual reliance and harm. The victim must actually rely on the false statements to her detriment. Courts are split over whether the reliance must be justifiable or reasonable. Justifiable reliance, false representation. Most courts require only justifiable reliance, which does not require the victim to act reasonably. For example, justifiable reliance does not require the victim to make a reasonable investigation to discover the statement's falsity. However, it is not justifiable for the victim to rely on statements that are patently and obviously false. Thus, if the victim should be able to tell at a glance that the statement is untrue, then reliance might not be justifiable. Justifiable reliance is a subjective standard, so whether reliance is justifiable in a given case depends much on the particular victim's knowledge, intelligence, and experience. Reasonable reliance, fraudulent representation. Some courts require the victim to use reasonable care to discover whether the statement is true or false. This standard may require the victim to reasonably investigate whether the statement is true or false. Only a few jurisdictions require justifiable reliance. Reliance in fact as standard for fraudulent misrepresentation. In a few jurisdictions, the victim need only prove reliance in fact. That is, the victim need only show that she relied on the misrepresentation. She need not show that the reliance was reasonable or even justifiable. Negligent misrepresentation arises if the actor makes a false statement of fact which the actor knows or reasonably should know is false, and the victim foreseeably relies on the misrepresentation and suffers financial damages as a result. Like fraudulent misrepresentation, negligent misrepresentation actions are an exception to the rule barring tort claims for purely economic losses. So, the limited application, the duty to avoid making negligent misrepresentations, applies only in limited settings. Typically, if the parties have a fiduciary or other relationship creating a legal duty to use reasonable care to provide accurate information, the actor is in the business of supplying information, the parties are involved in a commercial transaction, or the actor is under a public duty to convey the information. Most often, negligent misrepresentation applies if the parties take part in a commercial transaction. In any case, negligent misrepresentation applies only if the actor has a pecuniary interest in the transaction, even an indirect one. Pecuniary means relating to or consisting of money. So, false statement, negligent misrepresentation, as with fraudulent misrepresentation, the actor must make a false statement of past or present material fact. False, negligent misrepresentation. Liability arises if the actor knows or, in the exercise of a reasonable care, should know that the statement is false. Negligent misrepresentation, transactions to which liability extends. Liability for negligent misrepresentation extends only to loss arising from any transaction that the actor intends to influence or knows that the recipient intends to influence, or a substantially similar transaction. A good example of negligent misrepresentation transactions to which liability extends is a business consultant wrote a letter to a title insurance company, meaning to aid the company in selling the title insurance. In the letter, the consultant negligently praised the company's management, business practices, and public relations. In truth, the company was objectively mismanaged and, as a result, insolvent. Relying on the letter, a customer took out title insurance with the company and bought stock in the company, suffering pecuniary loss in both transactions. The consultant may be liable to the consumer for the loss she suffered on the title insurance, as the consultant wrote the letter to help the company sell title insurance. Yet the consultant is likely not liable for the customer's loss on buying stock in the title company. The consultant's decision to write the letter had nothing to do with selling stock. Foreseeable reliance, negligent misrepresentation. The circumstances must make it reasonable for the actor to foresee the victim's reliance on the false statement. Class of plaintiffs limited. Some jurisdictions. Some jurisdictions allow negligent misrepresentation claims only by those whom the actor intends to rely on the information, or those the actor knows will rely on the information in a transaction or type of transaction known to her. Put another way, the actor is liable for negligent misrepresentation only to the recipient of the information and third parties for whose benefit the actor intends to supply the information in a transaction or type of transaction known to the actor. It is not enough if the actor merely knows that the information might be shared with others, nor is the actor liable to all persons who might foreseeably rely on the information. Privity is required in some jurisdictions. Privity is a contractual relationship or a relationship so close and interdependent that it resembles a contractual relationship. Some courts require privity in an action for negligent misrepresentation. Class of plaintiff, actor under public duty to provide information. If the actor is under a public duty to supply the information, then liability for negligent misrepresentation extends to the entire class of persons for whose benefit the law imposes the duty. This duty, of course, extends only to transactions in which the duty was intended to protect the relevant class. Detrimental reliance, negligent misrepresentation. And this will wrap up our misrepresentation section. The victim must actually rely on the false statement, and that reliance must actually and proximately cause the victim's harm. Many courts treat the question of reliance in negligent misrepresentation in the same manner as fraudulent misrepresentation by requiring that the reliance be either justifiable or reasonable. And that wraps up our intentional torts section. The tort of defamation compensates a victim for harmful falsehoods communicated about the victim to third parties. Written defamation is called libel, and spoken defamation is called slander. Because defamation consists of speech, this tort arises or raises issues under the First Amendment of the United States Constitution. Accordingly, navigating a defamation case requires understanding two separate but interlocking sets of rules. One, the traditional elements of defamation, and two, the impact of the First Amendment on modern defamation. The traditional elements of defamation include the actor published a defamatory statement of fact and concerning the victim, which caused reputational harm to the victim. Traditional rule, truth as an affirmative defense. Under traditional defamation doctrine, the plaintiff need not prove the defamatory statement false. Instead, defamatory statements are presumed false, which means the defendant must assert the truth of the statement as an affirmative defense. Today, some states treat falsity as an element of the plaintiff's prima facie case. In addition, the plaintiff often has the burden to prove falsity if First Amendment concerns are implicated. Publication defined. Publication is any form of communication to a third person that is someone other than the victim who perceives and understands the communication. Fault regarding publication. The actor must negligently or intentionally cause the publication. This fault requirement has nothing to do with the content or effect of the statement. That is, it is not necessary that the actor intend to falsify, defame the victim, or that she be negligent about the statement's truth or falsity. Rather, the fault requirement relates to the fact of the communication, meaning the actor must communicate the statement by an intentional act or fail to use reasonable care to prevent the communication. The single publication rule in mass communications. Normally, each separate communication of a defamatory statement is a distinct publication. Thus, for statute of limitations purposes, a new cause of action will arise each time the statement is repeated. However, the rule differs in cases of mass communication, such as a book, newspaper, or website. In these cases, there is only one actionable publication occurring on the date of the initial publication. Of course, a new edition of a book or periodical or a substantive update, as opposed to a merely technical update to a web page, may be deemed a new distinct publication even under this rule. The republication rule. Under the republication rule, any third party who repeats a defamatory statement to someone else is independently liable for defamation. This is true even if the republishing party merely quotes or reports on the initial defamatory statement. Initial publisher's liability for republication. The person who first published the statement can be liable for any foreseeable publication or republication by others. Even repetition by the person defamed can be actionable, but only if this repetition is the natural and probable consequence of the initial publication. An example of this is a warehouse fired an employee. The warehouse's stated reason for the dismissal was that the employee had performed incompetently and embezzled funds. In fact, the employee had never embezzled, and she believed she had always performed competently. In seeking another job, the employee repeated those accusations to prospective employers in response to questions about her past employment, though she repeated the accusations only to refute them. Here, the warehouse may be liable for republication of each accusation on which the employee repeated the warehouse's accusations of incompetence and embezzlement. In this context, it seems natural and probable for the employee to raise and try to refute the accusations in seeking another job. Limitation on liability of secondary publishers. The republication rule has only limited application to secondary publishers. A secondary publisher acts as a conduit for material published by others, usually in the course of the secondary publisher's business. For example, a bookstore is a secondary publisher of the information contained in the books that it sells. A secondary publisher is not liable as a republisher of defamatory information unless the secondary publisher knows or has reason to know of the defamatory statements in the material. A secondary publisher is normally under no duty to examine the materials it sells for defamatory matter, unless perhaps there is unusual facts to put the secondary publisher on notice of the defamatory matter. Defamatory statement. Liability in defamation requires that the statement be defamatory. Defamatory statement defined. A defamatory statement is a statement of fact that tends to harm the victim's reputation. That is, a defamatory statement tends to expose the victim to hatred, contempt, or ridicule, or to cause the victim to lose goodwill, confidence, and esteem among others. The statement need not harm the victim's reputation in everyone's eyes. It is enough if the statement tends to harm the victim's reputation among a substantial minority of the community or among the victim's social or professional associates. Defamation per se and per quote. The defamation aspects of the statement may be obvious or implied. Obvious defamation is sometimes called defamation per se, and implied defamation is sometimes called defamation per quod. Either type of defamation is actionable. Defamation per se involves a statement that is defamatory on its face without reference to facts outside the statement itself. Defamation per quod involves a statement that is defamatory only if understood in the context of facts outside the statement itself. The extrinsic facts whose understanding is necessary to make the statement defamatory are sometimes called innuendo. An example is a city clerk falsely told a third party that a city official was embezzling money. This was defamation per se. The statement on its face accused the official of immoral and criminal activity. This accusation could be understood without reference to any additional facts. A second example is a police officer purchased a new car. A citizen stated to his friends that there was no way the policeman could afford the car on a public servant's salary. Both the citizen and the friend knew that the officer was under investigation for accepting bribes. This is an example of defamation per quod. In isolation, a statement that someone could not afford a car will likely not damage that person's reputation enough to be defamatory. However, if the context of the external fact, the innuendo, that the officer was being investigated for taking bribes, the statement made the defamatory implication that the officer bought the car with bribe money. Fact versus opinion, insult, or hyperbole. Defamatory statements must contain facts tending to injure the victim's reputation. A statement that merely conveys an opinion, an insult, or hyperbole is not defamatory. The distinction between fact and opinion is often a difficult one to make. The ultimate question is whether a reasonable third person would perceive the statement as fact or opinion based on the context of the statement and all other relevant circumstances. Fact. A statement will be treated as a statement of fact if it is set forth literal, objective, unequivocal information capable of being proven true or false. Facts couched as opinion. A statement that appears to be an opinion might nonetheless be treated as a statement of fact if the statement expressly states or necessarily implies particular facts. Mere opinion, insult, hyperbole, or puffery. A statement will be treated as an opinion insofar as it consists of hyperbole, insults, name-calling, or the speaker's mere subjective impression of actual facts. Of and concerning the victim. A statement is of and concerning the victim if someone who understands the statement could reasonably conclude that it refers to the victim. The question is not what the actor intends by the statement, but rather it is what a reasonable third party would conclude. Defamation does not require specific intent to refer to the victim. May I repeat? Defamation does not require specific intent to refer to the victim. Implied reference to victim. A statement that does not expressly refer to the victim may still make implied reference to the victim if either the statement sets forth facts, creating a reasonable inference that the statement refers to the victim, or the statement considered in conjunction with extrinsic facts creates a reasonable inference that the statement refers to the victim. Defamation of artificial entities. A corporation or other artificial entity can be defamed and thus has standing to sue for defamation, especially regarding statements that implicate the entity's honesty or integrity in conducting its business. However, statements that criticize an entity's services or products are usually not treated as defamatory. Some states provide a separate cause of action for product disparagement. Statements referring to groups. Special issues arise if a defamatory statement refers to a group or class of people rather than to a specific person. General rule: no group defamation. The general rule is that if the defamatory statement refers to a group of people without naming a specific person, then no person in that group may recover for defamation. Small group exception. Under the small group exception, all members of a group may recover for defamation if the group is so small that a recipient would reasonably understand that the statement refers to all of the group's members. Implied reference to a member of a group. A member of a group may have a defamation claim concerning a statement about the group if the surrounding circumstances reasonably indicate that the statement refers to the particular member. Decedents. A statement about someone made after that person's death is not actionable as defamation. Some states do, however, allow a pre-existing defamation case to continue as a survival action after the victim's death. Defamation or damages in defamation. Traditionally, a defamation plaintiff must prove damages consisting of actual harm to her reputation and related injuries. Sometimes damages may be presumed. General and special damages. Under the traditional law of defamation, there are two types of damages: general damages and special damages. General damages are awarded for reputational harm and related non-economic harm, such as mental anguish. Special damages are awarded for financial injuries following or flowing from general damages. For example, lost business. General damages presumed in some cases. In some cases, if the other elements of defamation are established, courts will presume that the plaintiff has suffered reputational harm without requiring further proof of reputational harm to satisfy the plaintiff's prima facie defamation case. Special damages are not presumed, but they must be separately proven. General damages are usually presumed only if the defamation is either libel or slander per se. Libel. Libel is defamation in writing, especially a writing published to an audience of significant size, such as a book, radio, magazine article, internet posting, motion picture, television broadcast, etc. Most courts presume general damages in any case of libel. So let me repeat that. Most courts presume general damages in any case of libel. The theory behind this presumption is that written defamation is apt to be longer lasting and more easily spread than spoken defamation, justifying a presumption of harm. Slander per se. Slander is defamation through spoken words. In slander cases, damages are presumed only if the statement falls within one of four special categories of slander per se, namely statements. 1. Accusing the victim of criminal conduct, that the victim is presently afflicted with a loathsome disease, such as a sexually transmitted disease or leprosy. 3. Imputing conduct or characteristics incompatible with the victim's profession or occupation. For example, that a doctor lacks medical training or that a merchant is insolvent. And 4. Accusing the victim of serious sexual misconduct, such as adultery or promiscuity. The second element was that the victim is presently afflicted with a loathsome disease. Special damages. If damages are not presumed, the plaintiff must plead and prove actual reputational harm, often by showing objective indicia of harm, such as lost business or harm to specific relationships. Once this is done, the plaintiff may then recover related economic or other damages in addition. Constitutional limits on defamation actions. The United States Supreme Court has held that the constitutional guarantee of freedom of speech places an increased burden of proof on defamation plaintiffs in specific cases. The scope of this increased burden will depend on whether the plaintiff is a public figure and, sometimes, whether the subject matter of the defamatory statement is of public concern or solely private concern. Public figures falsity, and actual malice. A plaintiff who is a public figure must prove all traditional elements of defamation plus the elements of falsity and actual malice. The standard of proof is also heightened beyond a preponderance of the evidence to require clear and convincing evidence. If the plaintiff is a public figure, there is no need to determine whether the statement involves a matter of public or private concern. The rule is the same in any case. Public figure defined. Broadly speaking, a public figure is either a public official or a private citizen who has attained a sufficient degree of notoriety, whether generally or in relation to a specific matter. Public official is someone who has significant responsibility in government, for instance, a city police commissioner. This may include policymakers as well as officials in positions that invite public scrutiny. Thus, not every government employee is a public official. In general, a plaintiff in government who is suing over statements about the plaintiff's work-related conduct is a public official. Persons of notoriety. A person who is not a public official may nevertheless be a public figure if the person has attained a sufficient degree of notoriety. There are two types of public figures of notoriety: general public figures and limited purpose public figures. General public figures are people of such pervasive notoriety that they should be treated as public figures for all purposes. Examples include well-known celebrities or famous athletes. It is not enough that the person is well known within limited professional or social circles. Instead, the person must be generally well known within a wider community, if not nationally. Limited purpose public figures. A limited purpose public figure is someone who voluntarily and substantially participates in a public controversy, usually to influence public opinion or to affect the outcome of the controversy. More rarely, this category can include someone drawn into a controversy involuntarily. A limited purpose public figure is treated as a public figure only with reference to the particular controversy in which the person is associated. Burden of proving falsity. If the plaintiff is a public figure, then the plaintiff has the burden to prove that the alleged defamatory statement was false as part of the plaintiff's prima facie case. This differs from traditional defamation, in which falsity is presumed and truth is an affirmative defense. Actual malice. Actual malice is knowledge of falsity or reckless disregard of truth or falsity. Knowledge of falsity. Actual malice exists if the actor subjectively knows that the statement is false. Reckless disregard of truth or falsity. Actual malice exists if the actor publishes the statement with a reckless disregard of whether it is true or false. Reckless disregard occurs if the actor seriously doubts the statement's truth, has a high degree of awareness that the statement is probably false, or deliberately ignores available information to avoid learning the truth. Mere failure to investigate the facts is not enough to show actual malice. Mere ill will insufficient. Actual malice does not exist just because the actor was motivated by ill will or dislike for the victim. Private figures. A private figure is someone who does not fit the definition of a public figure. The burden on a private figure defamation plaintiff depends on whether the subject of the alleged defamatory statement is a matter of public concern or purely private concern. Matters of public concern. If the defamatory statement includes a matter of public concern, then a private figure plaintiff must prove both falsity and the defendant's fault. Matters of public concern defined. A matter of public concern is a matter of legitimate news interest, not limited private interest. Matters of public concern include those implicating political and social concern, as well as those involving the public health, safety, morals, welfare, and policy. Proving falsity, matter of public concern. If a defamatory statement implicates a matter of public concern, then the private figure plaintiff must prove that the statement is false as part of her prima facie case. Proving fault, matter of public concern. If a defamatory statement implicates a matter of public concern, then the private figure plaintiff must prove some type of fault. Negligence required. To recover at all, The private figure plaintiff must at least prove that the defendant was negligent with respect to the falsity of a statement implicating matters of public concern. States are free to impose a higher threshold, such as actual malice, but are not required to do so. Matters of public concern, no presumed or punitive damages. Without actual malice, the plaintiff must prove actual injury from the defamation if it implicates a matter of public concern, and she is limited to recovery for actual injury actually proven. This means that damages may not be presumed at all, and the plaintiff may not recover punitive damages. The Supreme Court has defined actual injury to include reputational harm as well as pecuniary losses. Presumed and punitive damages for actual malice. A private figure plaintiff suing over defamation on a matter of public concern must prove actual malice to recover presumed damages or punitive damages. Actual malice obviates the need to prove actual injury. Presumed and punitive damages for actual malice. Now let's go into matters of purely private concern. If the defamatory statement involves a matter of purely private concern, then a private figure plaintiff faces no constitutional restrictions. The case will proceed according to the ordinary defamation law of the relevant jurisdiction. Matters of private concern defined. A matter of private concern is a matter that implicates only the interest of the actor and the actor's limited audience. The matter does not implicate public health, safety, morals, welfare, or policy. Privileges and defenses to defamation. A defamation defendant may avoid liberty or liability by establishing a defense or a privilege to defamation. The major defenses are consent and truth. The privileges are divided into two categories: qualified privileges and absolute privileges. Consent is a defense to defamation. Here, consent does not require that the victim know the statement's defamatory character. It is enough that she knows either its precise contents or, if she does not, at least that it might be defamatory. Truth as an affirmative defense in some cases. If the plaintiff does not have the burden to prove falsity as part of her prima facie case, then under traditional defamation principles, the truth of the statement is an affirmative defense. No defense for attributing defamatory statement to another. An actor may be liable as a republisher for repeating a defamatory statement even if the actor truthfully attributes the original statement to someone else. Qualified privileges. A qualified privilege is one that can be lost through abuse. The most important qualified privileges are the fair reporting privilege, statements made in the public interest, the fair comment privilege, and statements made in support of the private interests of the speaker and others. Fair reporting privilege. A fair reporting privilege applies if the actor fairly and accurately reports or summarizes an official proceeding or public meeting that deals with a matter of public concern. Public proceedings defined. Public proceedings include governmental and judicial proceedings in which official action is taken or contemplated, as well as non-governmental proceedings of significant public interest. Also, in this context, the term proceeding includes discrete events that one might not deem to be proceedings at first blush. For example, an arrest by the police may be treated as a public proceeding. Accuracy required. The fair reporting privilege covers only accurate reports. An inaccurate or embellished report that does not constitute a fair summary of the proceeding is not privileged. However, immaterial errors that do not bear on the essential truth of what took place will not defeat the privilege. Fairness required. For the fair reporting privilege to apply, the report must be fair. This means the report must be even-handed. If the report is unduly skewed in favor of one side, in a context in which opposing or diverging viewpoints are at play, the privilege may not apply. More fundamentally, a report is unfair if, though it is accurate as far as it goes, it is materially misleading because it omits context or other relevant information. So the restatement view of actual malice, not abuse. According to the restatement second of torts, the fair reporting privilege is almost absolute. The only way to abuse it and thus lose it is to convey a report about a public proceeding that is not substantially accurate or fair. If the report is conveyed with actual malice, that is, with knowledge or reckless disregard of the falsity of any defamatory matter conveyed, then the privilege may still apply so long as, objectively speaking, the report is a substantially accurate and fair accounting of what transpired at the public proceeding. Statements in the public interest. The privilege protecting statements made in the public interest applies if the circumstances induce a correct or reasonable belief that there is information affecting a public interest. That interest is sufficiently important, and in the public interest, the actor must communicate the information to either a public official or to a private citizen who, provided the information is true, is authorized or privileged to act. Examples of sufficiently important public interests. Examples of public interests sufficiently important to evoke the privilege for statements made in the public interest include the interest in preventing crime and apprehending criminals, public officials' honest performance of their duties, and enacting laws to address significant societal ills. Matters on which a public official is authorized to act. Matters on which a public official is authorized to act generally include matters falling within the scope of the official's duties. Perhaps a prime example involves the conduct of other public employees who answer to the relevant public officer. Thus, a report to a superior public officer concerning the official activities of her subordinates may fall within the privilege for statements in the public interest. Another example includes information conveyed to legislators concerning pending legislation. Statements to a private person. According to the restatement second of torts, a statement to someone who is not a public official, that is, a private individual, may fall within the privilege for statements in the public interest. In this context, the privilege generally applies only if the private individual would be privileged to take action if the defamatory statement were true. For instance, the private individual may be privileged to use force to prevent a crime or apprehend a criminal. Fair comment privilege. The fair comment privilege protects certain statements of opinion or commentary on matters of public interest. For this privilege to apply, several criteria must be met. Opinion or criticism only. The fair comment privilege protects only statements of opinion or commentary, not statements of fact. Statements based on facts disclosed or generally known. The fair comment privilege does not protect opinion or criticism based on undisclosed facts. Rather, it protects opinions based on facts that are disclosed by the speaker, generally known, or generally accessible. Statements based on true, assumed, or privileged facts. The fair comment privilege protects only opinions or criticisms based on facts that are true, assumed true, by both the speaker and the recipient, or gleaned from a prior statement that is itself privileged under defamation law. The privilege does not protect opinions based on false, defamatory, unprivileged facts. Statements concerning matters of public interest. A fair comment privilege protects only opinions or commentary concerning matters of legitimate public interest. The concept of matters of legitimate public interest is defined very broadly in this context. For example, a report about patient satisfaction with a renowned plastic surgeon services would likely be a matter of legitimate public interest, as it concerns public health and the availability of competent physicians. Statements in support of private interests. A statement made in support of the private interests of the speaker or someone else can be privileged under the right conditions. Interests of another. A statement made in support of the private interests of someone other than the speaker may be privileged. Statement relates to sufficiently important interest. For the private interest privilege to apply, the speaker must correctly or reasonably believe that the defamatory matter pertains to a sufficiently important private interest. A sufficiently important interest is generally one for which the law affords protection, such as a property or pecuniary interest. For instance, the conduct of one's employees in the course of their duties generally implicates a sufficiently important interest. Reasonable necessity. The speaker must reasonably believe that communicating the matter to the recipient is necessary to protect the interest. General standards of decency. Communicating the defamatory matter should comport with general standards of decency. A factor of paramount importance is whether the speaker communicated the defamatory matter gratuitously or on request. Many statements will be privileged if made on request. Another important factor is whether there is a relationship between the parties whose interests the statement implicates, such as a family or business relationship. One safe harbor here is that communication of the defamatory matter will normally fall within generally accepted standards of decency if the actor has a legal duty to publish the defamatory matter. For instance, a fiduciary, such as a trustee or attorney, often must convey information to the beneficiary or client in the course of her duties. General standards of decency, defamatory matter not communicated on request. If defamatory matter is communicated gratuitously, not a request, then it might still fall within the privilege. Even so, the actor must carefully evaluate the interests sought to be protected and must balance the likely harm of the victim's reputation against the harm to the third party's interest if the defamatory matter is not conveyed. Common interest privilege. The common interest privilege is similar to the privilege protecting statements in the private interest of others. The common interest privilege applies if people have a common interest or meaningful stake in a particular subject. These people have a qualified privilege to exchange information germane to their shared interest. Interest protected. The interest that the speaker seeks to protect should generally be a business, pecuniary, or professional interest. Commonality of interest necessary. The interest that the speaker seeks to protect must be a shared or common interest among the speaker, the recipient, and perhaps others. Membership in some identifiable group with shared values or a common endeavor is a typical example of a shared interest. Also, the privilege often applies if the speaker and the recipient share business dealings together, for instance, the business relationship between a franchisor and franchisee. Reasonable relationship between communication and interest. There must be a reasonable relationship between the communication and protecting the common interest. Reasonable belief in recipient's right to know. The speaker must reasonably believe that the recipient is entitled to know the defamatory information. Generally, anyone who genuinely shares the common interest will be entitled to know the information. Self-vindication privilege. A statement may be privileged if the speaker makes a statement to protect a sufficiently important interest, for example, a business or pecuniary interest or some other interest protected under the civil or criminal law of the speaker's own, provided the speaker reasonably believes that conveying the statement to the recipient would aid in lawfully protecting that interest. This privilege is often invoked by speakers responding to attacks on their own reputations, though the privilege may arise in other contexts. Abuse of qualified privileges. A qualified privilege is considered to be abused and thus lost in one of four situations: actual malice as abuse, excessive publication, publication for unrelated purpose, and unnecessary publication. So, actual malice as abuse, except for the fair reporting privilege, a qualified privilege is abused if the actor publishes the defamatory matter with actual malice, that is, knowledge or recklessness or reckless disregard of the statement's falsity. Some courts also find abuse if the defamatory statement is communicated with evil motive, bad faith, or ill will. Excessive publication. A qualified privilege may be abused through excessive publication. Excessive publication occurs if the actor communicates a defamatory matter to a third party, and the actor cannot reasonably believe communications to that third party would serve the interest the privilege is meant to protect. Of course, as the restatement, second edition of Torts notes, it is often true that communication of the defamatory matter to those with no need to hear it is unavoidable. Here, the privilege might not be abused if the communication is reasonable, given the importance of the interest at stake, the gravity of potential harm involved, and the inconvenience of any other method of publication. Publication for unrelated purpose. A qualified privilege is abused if the actor publishes the defamatory matter for some purpose other than advancing the interest and privilege was designed to protect. Thus, if a statement is made solely out of malice or ill will and not in any way to advance the relevant interest, then the privilege is abused. Yet, if the statement is really made to protect the relevant interest, then the privilege might apply even though some resentment or ill will underlies it. But a statement not made to protect the relevant interest abuses the privilege even if made without malice or ill will. For example, a newspaper reporter might publish a defamatory article solely to create sensationalism and sell newspapers or generate website traffic rather than to protect any interest protected by a qualified privilege. Unnecessary publication. A qualified privilege is abused if the actor cannot reasonably believe that publishing the defamatory matter is necessary to advance the interest protected by the privilege. Absolute privileges. An absolute privilege is a complete defense to liability for defamation, even if the privilege is abused. Legislative statements. State and federal legislators enjoy an absolute privilege for statements made in the course of their legislative functions, including floor debates, committee work, and other legislative business. The privilege applies even if a statement is irrelevant to any matter under consideration. The privilege does not apply, however, to statements made by a legislator not engaged in legislative business, such as campaigning or public relations. Executive privilege. Officials of the executive branch of any government enjoy an absolute privilege for communications made in the course of their public duties. Unlike the legislative privilege, the executive privilege requests that the statement bear a reasonable relationship to the official's executive functions. The restatement second edition of Torts would apply this privilege only to an executive or administrative officer in the federal government, and the governor or any supervisor executive official in a state government. Let me say that again. It applies to any executive or administrative officer in the federal government and the governor or any superior executive official in a state government. In accordance with the restatement, many states apply the privilege only to high-ranking executive officials in state government, such as department heads or cabinet-level officials. Some states, though, extend the privilege to lower-ranking state officials. Statements made in judicial proceedings. Statements in the course of judicial proceedings are absolutely privileged, provided they are reasonably related to the subject matter of the litigation. The privilege encompasses papers filed in court, witness statements, statements by attorneys, and settlement communications between parties. Some authority also construes the privilege to apply to statements, for example, statements between attorneys and their clients made before litigation has commenced, provided litigation is seriously contemplated. For instance, allegations made in a draft complaint that has not yet been filed might be privileged. Communications between spouses. Communications between spouses are absolutely privileged. Communications required by law. If an actor is legally required to make or permit particular communications without censorship, the actor is generally immune from liability for any defamatory matter contained within the statements. Broadcasting laws requiring a station to give equal time to political candidates and to refrain from censoring political communications by legally qualified candidates for political office are one example. Another intentional tort is invasion of privacy. Privacy is protected by 4 independent causes of action: commercial misappropriation of identity, intrusion upon seclusion, false light, and public disclosure of private facts. Misappropriation of identity arises if the actor utilizes the victim's identity, name, or likeness for the actor's own purposes without the victim's consent. The tort usually involves misappropriation for commercial gain. Through misappropriation for other purposes may also be actionable. For instance, a husband's paramour may misappropriate the identity of the husband's legal wife by going about posing as his common law wife and adopting his last name as the paramour's own. This proposition holds true even though there is no apparent commercial benefit to the paramour. Permissible incidental use. There is no liability if the actor merely refers to the victim or uses the victim's identity for purposes other than exploiting the commercial or financial value associated with it, even if the actor makes money by doing so. This rule is especially likely to apply to information about public figures who cannot rely on the tort of misappropriation of identity to shield themselves from criticism and commentary. Intrusion upon seclusion. Liability for intrusion upon seclusion arises if the actor intentionally and intrudes upon the victim's solitude, seclusion, or private affairs, and the intrusion would be highly offensive to a reasonable person. Physical or other intrusion. Perhaps more often the actor will intrude physically by sense-enhancing devices or otherwise upon the victim's solitude, seclusion, or private affairs. Examples include voyeurism, eavesdropping, peeping, harassment as by repeated and unwanted phone calls, breaking into the victim's private home, and so on. Yet the intrusion need not always be physical and thus may occur by some other investigation or examination of the victim's private affairs. For instance, an actor may open the victim's private mail or deceive the victim's bank into letting the actor examine the victim's financial information. Private affairs. The matter upon which the actor intrudes must actually be private. There is no liability if the matter has already been exposed to the public or is a matter of public record or knowledge. For example, an actor is not liable for surreptitiously photographing or observing someone who is already in a public place, nor for gleaning information about the victim from public records. Intent. The intrusion must be intentional, not accidental or negligent. High degree of offense to a reasonable person. The intrusion upon private affairs must be highly offensive to a reasonable person. Examples of highly offensive intrusions include eavesdropping, looking through windows, trespassing in someone's home, examining someone's banking records, and unwanted bodily touching. All these involve intrusion upon matters that the victim would reasonably expect to remain private. False light. The tort of false light is recognized in most but not all jurisdictions. False light often overlaps with defamation. However, there is important differences between the two. Elements of false light. A claim for false light arises if the actor publicizes false information about the victim, and the false portrayal would be highly offensive to a reasonable person. Some courts may also require some fault or even actual malice, especially if the victim is a public figure. Publicizing information, false light. The term publicizing is used in false light should be distinguished from the term publication as used in the law of defamation. In defamation, publication occurs if the actor communicates defamatory material to even a single third party. Publicizing in false light requires much wider communication, either to the public at large or to so many people that the falsehood is likely to become a matter of public knowledge. Publicizing can involve a smaller audience if the victim shares a special connection with that group, so that the group's opinion is especially important to the victim. These groups might include coworkers or fellow church members. Placing victim in false light. The publicized information must put the victim in a false light. This is the case if the information falsely attributes characteristics, beliefs, history, or conduct to the victim. False information, highly offensive to a reasonable person. The matter publicized must be highly offensive to a reasonable person. The false matter does not need to be defamatory. That is, false light must not require that the victim suffer harm to reputation. constitutional limitations, and the fault requirement. The court takes differing views about what level of fault must be shown in a false light claim. As in defamation law, the question of fault can implicate constitutional protections for free speech. The cases reflect at least three different approaches. The first approach is applying constitutional limits on defamation to false light. Some jurisdictions apply the constitutional limitations on defamation claims to false light claims as well. These jurisdictions require actual malice if the victim is a public figure and at least negligence if the victim is a private figure suing about a matter of public concern. The second approach is special rules for matters of public concern. Some jurisdictions require actual malice if the false light involves a matter of public concern, regardless of whether the victim is a public or private figure. Some of these same courts require only negligence as to truth or falsity if the victim is a private figure and the matter is one of purely private concern. Actual malice, the third approach is actual malice in all false light cases. Some jurisdictions require actual malice in all false light cases, regardless of who the victim is or the subject matter involved. The tort of public disclosure of private facts provides a cause of action if the actor has publicized particular kinds of truthful information about the victim. Some courts do not recognize this cause of action, though most do. The claim arises if the actor publicizes private facts about the victim, the disclosure of which would be highly offensive to a reasonable person, and those facts are not a matter of legitimate public interest. Publicity in public disclosure of private facts. The actor must publicize private facts about the victim. As with false light, publicizing requires communication either to the public at large or to so many people that the fact is likely to become a matter of public knowledge. Private, truthful facts. The true facts that the actor publicizes must be truly private facts. Information that is publicly known or publicly accessible cannot be considered private. Highly offensive to a reasonable person. Public disclosure of private facts. Disclosure of the private information must be highly offensive to a reasonable person. Examples include medical information. An example would be the fact that a woman had a hysterectomy, financial information, and sometimes information about the victim's sexuality. No legitimate public interest. Public disclosure of private facts. The matter publicized must not be a matter of legitimate public interest. The concept of public interest is construed broadly. Matters of public record are matters of public interest, as are matters regarding the commission of a crime and its consequences. An example of this is 6 teenagers raped and murdered a 17-year-old girl. Soon after the teenagers were arrested and charged with rape and murder, the newspaper reporter gleaned the essential facts, including the girl's name, from the indictment, a matter of public record, and publicized those facts in a news article. The girl's father sued the reporter for public disclosure of private facts. The father's claim will fail. Though disclosure of the girl's name and of the brutal sexual assault she suffered might reasonably highly offend the father, the occurrence of this crime and the related facts were matters of legitimate public concern. Privileges and defenses to private or privacy torts. Generally, the privileges and defenses that apply to defamation also apply to privacy torts. This means consent is a defense to privacy torts. The last intentional torts that we will look through is the tortious interference with business relations. Interference with business relations is addressed by two torts with overlapping elements: intentional interference with contract and intentional interference with economic opportunity. The elements are: tortious interference occurs if the actor intentionally interferes with a victim's existing contract or prospective economic opportunity and thus causes economic harm to the victim. existence of a contract or prospective economic opportunity. Tortious interference requires the existence of either a valid contract between the victim and a third party or a prospective economic opportunity not yet memorialized in contract involving the victim and a third party. Broadly speaking, a prospective economic opportunity is any potential transaction that could reasonably benefit the victim financially. Examples include a job opportunity, the prospective sale or purchase of property or services, or an option to renew or extend a contract, and other relationships that might lead to profitable contracts. The actor's knowledge of contract or opportunity. The actor must know of the contract or the prospective opportunity. Intentional interference with contract or opportunity. Intentional interference requires that the actor intentionally induce a third party to breach a contract with the victim or disrupt the victim's economic opportunity. The actor may disrupt the opportunity by including the third party to abandon or inducing the third party to abandon the opportunity or preventing the victim from acquiring the opportunity. In the case of a prospective opportunity, some jurisdictions require conduct amounting to unlawful or unfair competition, especially if the actor is the victim's competitor. Improper interference. Liability for tortious interference requires that the actor's interference with the contract or prospective economic opportunity be improper. In this context, impropriety is a fairly nebulous concept that defies a bright line definition. Broadly speaking, conduct is improper if it is fair and reasonable under the circumstances. Conduct is proper if it is fair and reasonable under the circumstances. Even so, let's just go on to the nature of the actor's conduct. Well, actually, let's go into some exceptions. With some exceptions, conduct inducing a third party to breach a binding contract not terminable at will is virtually always improper. Nature of the actor's conduct. A prime factor in determining whether interference is improper is the nature of the actor's conduct. In this vein, criminal or tortious activity is typically improper. Examples include violence, threats of violence, fraudulent misrepresentation, and other actionable conduct. Actor's motive for interfering. The actor's motive for the interference is a factor in determining whether the interference is improper. A closely related factor is the particular interest that the actor seeks to advance by her conduct. If the actor's sole purpose is to interfere with another's contractual relations, the interference is almost always improper. But if the actor seeks to advance the public interest, this may weigh in favor of finding the interference proper. Interest with which the actor interferes. The interest with which the actor interferes is a factor in determining whether the interference is improper, especially if the interference is with a prospective economic opportunity. Again, interference with a binding contract not terminable at will is usually improper. Competing social interest. In determining whether interference is improper, courts should generally balance the social interest in the actor's freedom to act against the victim's interest in the transaction. Causal connection between the actor's conduct and the interference. In determining whether interference is improper, courts should consider the strength of the causal connection between the actor's conduct and the interference. The more direct the actor's conduct causes the interference, all other things equal, the more likely the interference is improper. Contrariwise, the more indirect the causal relationship, the less likely the interference is to be improper. For instance, if the actor directly induces a third party to breach a contract with the victim, then this conduct is likely improper. Yet, if the actor's conduct causes A to breach her contract with B, which prevents B from fulfilling a separate contract with C, the connection between A's conduct and the interference with C's contract is substantially more attenuated and hence less likely to be improper. Relationship between the parties, tortious interference. The parties' relationship is a factor to consider in determining whether the actor's conduct is improper. For instance, conduct that is proper if the parties are business competitors may be improper if they share another relationship, and if the actor bears a fiduciary or similar relationship with a third party. The actor might be justified even to induce the third party to break a binding contract with the victim. And that's in a situation if an actor bears a fiduciary or similar relationship with the third party, the actor might be justified even to induce the third party to break a binding contract with the victim. Harm, tortious interference. The victim must suffer economic loss because of the interference. The intentional interference torts are exceptions to the rule barring tort recovery for purely economic losses. Provided the victim suffers economic harm, she may also recover for other harms that the interference causes, such as emotional distress or harm to reputation. Justifications for interference. Several justifications, if established, will prevent liability for intentional interference. Lawful competition. With respect to prospective opportunities, an actor may use lawful means of competition to attract customers, even if those customers would otherwise have dealt with the victim. Lawful competition typically does not excuse deliberate interference with an existing binding contract, not terminable at will, of which the actor has knowledge. Competitor defined. Generally speaking, a competitor is one vying for the same potential customers in the same or a similar trade or business, or seeking the right to acquire or sell the same property. Requirement that interference concerns subject of competition. For the justification for lawful competition to apply, the interference must concern the subject of the competition between the actor and the victim. Actor's legitimate self-interest. An actor will not be liable for intentional interference for acting lawfully and in good faith to protect the actor's own legitimate business interest. Usually, this rule applies if the actor has an interest in the third party, typically an investment. Examples include stockholders, partners, and other equity stakeholders in the third party's business. Creditors or bondholders might also benefit from this rule. This rule normally does not justify interference with a binding contract not terminable at will. Advice to others. Also, interference may be justified if it is by one who is what I meant to say is also interference may be justified if it is by one is to some degree responsible for the third party's welfare, provided the actor employs lawful means and sincerely acts for the third party's benefit. For instance, a school is responsible for its students' welfare, and a doctor is responsible for her patient's well-being. Under this rule, it may even be justifiable for the actor to induce an outright breach of contract. To reiterate, interference may be justified if it is by one who is to some degree responsible for the third party's welfare. So, truthful information or advice in response to a request. An actor is not liable for tortious interference merely for conveying truthful information to someone else. Similarly, an actor normally is not liable for tortious interference just because she gives lawful and honest advice in good faith within the scope of a request for advice. This rule applies even if the result is an outright breach of contract by the third party.